This week, I want to discuss with you an old favorite case of mine. It's favorite because I think the judges were clairvoyant in their predictions. And it's also favorite because it's so old and it gives sometimes not that great a picture of how colonial powers looked at their colonies. But either way, we're going to talk about the De Beers Consolidated Mines case, where it was against HOWE, which was the assessing officer, and we're talking about decisions from 1903, between 1903 and 1905. So here is the decision from the House of Lords. So let us see what it said. It starts with the facts. At a meeting of the Commissioners of the General Purposes of Income Tax Acts for the City of London, held at Guildhall in the said city on Thursday, the 31st of July 1902, the De Beers Consolidated Mines Limited, hereafter the appellant, of 62 Lombard Street on the City of London appealed against a supplementary assessment made upon them for the year ending on the 5th of April 1901 in the sum of £1,557,000. I've not recalculated what that is in today's money, but I'm quite sure it is enormous. And against an additional assessment for the year ending on the 5th of April 1902, remember these are the English tax years, in a similar sum of 1,558,000 in respect of profits of the company in the United Kingdom and elsewhere. The appellant company was registered with limited liability in the Deeds Office of Griqualand, so that's in the Cape, Griqualand West, in the colony of Cape of the Good Hope, hereinafter for brevity termed the Cape Colony, on the 13th of March 1888. So it was in existence for 13 years already by that time. The appellant company was not registered in the UK as a joint stock company. So this is the basic facts. So it say that the company was resident in the UK, and then it starts talking about the De Beers company itself. By Article 3 of the Articles of Association, it is provided that the head office of the company shall be in Kimberley in the Cape of Good Hope. The company have offices at London and at Kimberley, right? So it had two offices at least. The appellant company owns or is interested in extensive diamond mines and mining property in South Africa. Now you need to realize by this time De Beers was clearly the largest diamond mining company in the world. It basically had a monopoly on the global diamond market. And what is, if you look at what happened 30-40 years later, De Beers, you saw the ad on the beginning of discussing this case. A diamond is forever. Until De Beers came about, I mean, diamonds were rock hard and everything, but they were just stones, and they were useful in production process because they were harder than most other things around at the time. But they were not symbols of romance and love and marriage and all that kind of stuff. And De Beers turned this around with this slogan from, I think it's the late 30s, of a diamond is forever, right? A diamond was, and they started marketing diamonds as engagement rings for showing love and commitment and everything. And people paid tons of money for that and still do, even though the resale value of a diamond is actually very low because its usability, other than for industry, is not that great. But De Beers changed this and built a perception. It is one of the most successful marketing stories in the history of marketing, right? So one has to keep that in mind as well, right? If we look at point 5, the appellant owns or is interested in extensive diamond mines and mining property in South Africa, and that's where the world's biggest diamond mines were, in Kimberley, where even to this day there is a huge hole where I think it must be almost like a kilometer across, and it is so deep that you can see swarms of birds flying in the bottom of this hole, and it simply dwarfs any building at the top of the hole. And that was man-made basically at the time, right? So the profits of the company during the years of assessment and for many years previously have been chiefly made by the raising and sale of diamonds the produce of their said mines to a syndicate composed of 6 or 7 firms of diamond merchants with whom the company had a series of contracts in that behalf since the year 1895. The said contracts were negotiated and executed in London, and the firms composing the syndicate are all therein described as of London. The object and effect of such arrangements by the company is to regulate and support the market of diamonds. And if you look at the De Beers history on their website, you will see that what happened was there were 2 gentlemen, one of them being Cecil John Rhodes, who in the years previous to all of this were trying to become the monopolists of the diamond mining industry in South Africa. And these 2 gentlemen competed the hell out of each other in buying as many mines as possible and then selling as many diamonds as possible, with a consequence that they completely flooded the market with diamonds, and the diamond price collapsed completely. And they realized that the only thing that they could do was to cooperate, to work together so that they could control the flow of diamonds into the world market and keep the price of diamonds high by artificially limiting the amount of sales of diamonds, right? And that is what this last paragraph referred to as well. And if we then look at the management of De Beers, it'll be the next page or 2 that we discuss this, because this is about what is about. Where was De Beers, the South African company with a South African mind and a South African mine and a South African board and annual general meetings held in South Africa? Where was this company really resident, right? And where was it managed and controlled? Because this was a relatively new issues in 1902 in the UK courts, one would assume. There have been cases before, but still, the doctrine was not fully developed if one considers how often the De Beers case was referenced thereafter in cases about tax residents. So paragraph 8 says, the management of the business under control of the appellant company during the years of assessment was under the provisions of Articles of Association vested in 3 life governors and permanent directors and 16 ordinary directors, right? And then it says under the Articles of Association, it's provided that 4 at least of the directors shall reside in England. And then point 9, meetings of directors have been held at the company's office in London weekly since the 21st of November 1888. Weekly meetings of directors have also been held at Kimberley during the same period, and minutes kept. At the first meeting, that's just talking about the first meeting, and then it says minutes of the preceding meetings, at all meetings in London and Kimberley were duly kept. There is an exchange of minutes between the 2 places, London and Kimberley, and God knows how long it took for at that time to get these minutes across to each other, right? Unless they read them to each other by phone, if telephones existed at that time. The proceedings of the board of directors sitting in Kimberley and London are regulated by bylaws, and these bylaws have been drawn up in London and communicated to Kimberley. So here already you feel a shift of, London tells Kimberley what we're going to do. And then they quote the bylaws, and it says, the bylaws are as follows: the course of business as respects the technical management of the company's work and operations at its mines, and the expenditure therefore for wages, materials and such like, shall be determined by the directors for the time being in Kimberley. So the mining is in Kimberley, who will, however, wherever practical, consult the directors for the time being in London on matters of exceptional importance, so strategic management. All other expenditures exceeding £25,000 shall be determined upon by the majority of all directors in London and Kimberley for the time being, and the policy of the board, A, as respects the disposal of its diamonds or other assets, B, in connection with the working or development of the company's mines and the output of the diamonds, C, as respects the application of the company's profits, and D, as respects appointment of elected directors and the filling up of casual elective vacancies, filling up of casual elective vacancies in the board of directors shall be determined by the majority of all directors for the time being. So yes, the company was situated in South Africa, but it was the majority of directors in London and South Africa which determined the vast majority of important decisions in the company. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. And then they talk about the years 1901 and 92. There was including 3 life governors and a total of 19 directors, right? In each of these 16 years, in each of these years, 16 of the said directors at one time or another attended the meetings. So 16 out of 19 attended the meetings. 2 of the 3 life governors and 9 of the 16 ordinary directors were resident in the UK. So the majority of the ordinary directors and of the life governors were resident in the UK. The Right Honourable Cecil John Rhodes, Chairman, and 6 ordinary directors were resident in the colony. I like how they use the word colony instead of South Africa. And then 1 director had a residence in each country. The average attendance of ordinary directors at the London meetings was largely in excess of the average attendance at the Kimberley meetings. So there were always more directors taking part in the meetings from London than from Kimberley. The evidence showed that the matters falling within the terms of Clause 3 of the bylaws, so this is all these decisions, were always dealt with at meetings of the directors in London, where the majority of all directors always were matters of where the majority of all directors were matters of policy within said clause were discussed and approved and then communicated to Kimberley. So clearly the initiative was lying in London, right? There is no instance of the vote of the Kimberley directors turning a minority in London into a majority or negativing the decision of the London board. It was admitted that the majority of the directors had always given their votes in connection with any important matter to be determined under Bylaw 5 at the meetings of the board in London, and that was simply that you could second someone to make the decision for you. And then it also said that the London directors had 4 committees, being a finance committee, a diamond committee, machine committee, and a dynamite committee, and the finance committee just did the accounts and stuff like that. The diamond and repayments of debt and issues like that. The diamond committee was first appointed in 1889, and under its direction and control, the company's diamonds received in London were arranged to be disposed of. So they took care of the sale of diamonds. The Machinery Committee, first appointed on the 5th of December 1888, executes in London all orders from Kimberley for the purchase of machinery and plant for the company's use. The Machinery Committee acts only on requisitions from Kimberley and never initiate policy relating to machinery. Their function is control, right? And the same for the Diamond Committee. It never initiates any policy. Their function is control. So control was, according to this, in London. And then if you look for the last part about the management, in addition to the above transactions, various other transactions, so it's a sale of the diamonds, of considerable magnitude were considered, arranged and carried out by the directors in London and the said committees, right? And then they start with a whole list of transactions. The directors meeting in London carried through the following important financial and other transactions: the consideration in May 1889 and final approval in October 1889 of an agreement acquiring the Bultfontein Consolidated Mining Company. So De Beers went on a spree of buying, or continued its spree of buying, as many mining companies in South Africa as possible. Then you look at B, the approval and signing and sealing in London with a common seal of the company on the 26th of June 1889 of an agreement for the purchase of the Pullinger Company, which has been referred to Kimberley. And then it goes on to C, D, E, F, G, comes to Q finally on the 26th of February 1902, approved and signed and sealed with the company's seal in London, an agreement with the Consolidated African Copper Trust. So all the major agreements, acquisition, partnerships and stuff like that were decided in London, is what this list is saying. And then further, the judge says in all these cases, it was stated in evidence that the transactions were always subject to confirmation at Kimberley. But this is only true in the sense that the majority of the directors did not use their power as such majority without formal communication with their colleagues in Kimberley. So basically, Kimberley always played along whatever London decided. And then we come to the arguments of the parties. De Beers contended that it was not resident in the UK and that it does not exercise any trade within the UK and is not subject to assessment to income tax in the UK. And I guess Inland Revenue at that time, I don't know what they was called in 1901, said on behalf of Revenue it was contended that the operations of the company were controlled from London by the directors here, and that London was the real seat of his business. So that was the first one, it was tax residence. But the second argument in the Beers case was actually permanent establishment, because if you look at the next paragraph, it says it was further contended as an alternative that as the whole produce of the mines of the appellant company has been habitually disposed of under contracts made in England with the Diamond Syndicate in the manner and to be effected herein above mentioned, the appellant company exercised a trade or business within the UK and was chargeable to income tax on the whole of the profits made by them from the sale of the produce of the said mines under the said contract. So they never got to the PE argument, but the UK tax authorities had a backup argument with regard to the PE. And obviously there was an office in London. I don't know what if there even was a treaty with South Africa in that time, or what the UK local law wording was for defining a treaty, PE, but one would assume that it's something like exercising a trade or business, an active trade or business. Maybe one thinks of the US jargon. So this is what they had. And then the judge comes to, I think there were 5 judges, but all of them agreed on the residence of the company, and the leading judge writing the opinion said, the question as to whether De Beers Consolidated Mines Limited ought to be assessed to income tax on the footing that it is a company resident in the UK. And then the judge explains why he comes to the conclusion that the answer should be yes. He says, in applying the conception of residence to a company, we ought, I think, to proceed as nearly as we can upon the analogy of an individual. See that the thinking was still developing here. A company cannot eat or sleep, but it can keep house and do business. We ought to therefore see where it really keeps house and does business. An individual may be of foreign nationality and yet reside in the UK, so may a company. Otherwise, it might have its chief seat of management and its centre of trading in England under the protection of English law and yet escape the appropriate taxation, right, by the simple expedient of being registered abroad and distributing its dividends abroad. So saying, you know what, this would be too big of a loophole to allow. The decision of Chief Baron Kelly and Baron Huddleston in Calcutta Jutta Mills and Cecina Sulphur Company, now 30 years ago, so there have been older cases on residence, involve the principle that a company resides for purposes of income tax where its real business is carried on. And then the judge said, so let's see where the real business of De Beers is carried on. And said the head office is formerly at Kimberley. Also, the profits have been made out of diamonds raised in South Africa, right? But further, some of the directors and life governors live in South Africa, and there are directors' meetings at Kimberley as well as in London. But it is clearly established that the majority of the directors and life governors live in England, that the directors' meetings in London are the meetings where the real control is always exercised in practically all the important business of the company, except the mining operations. And the mining operations are simply seen as not creating the real value for the company, right? London has always controlled the negotiation of contracts with the diamond syndicates, has determined policy in the disposal of diamonds and other assets, the working and development of the mines, the application of profits, and the appointment of directors. And the story with the diamond syndicates is that De Beers, once Cecil John Rhodes and the other gentlemen in South Africa joined forces together and worked together as one force, they actually managed to find a syndicate of diamond trading companies, some of the largest companies in the UK, pretty much controlling the world market on diamonds, and agreed to sell, I think, exclusively to them. So there was a very powerful partnership between De Beers and the syndicate of diamond dealers in the UK. And then the judge concludes, these conclusions of fact cannot be impugned, and it follows that this company was resident within the United Kingdom for the purpose of income tax. And then one of the concurring judges agreed and said, Lord James of Hereford, my lord, I concur in the judgments that have been delivered, holding that the decision of the Court of Appeal should be affirmed. In other words, that De Beers is resident in the UK. It is true that the appellant company was registered in a colony, and it was contended that this registration constituted a foreign company which could not be resident within the United Kingdom. But I see no reason why this should be the case. Of course, a foreigner can reside here, and so can a foreign company. See, this is as if this is still a moot point in the UK at this point, right? Then a little further down, he says, then upon the facts, it seems clear that the business of diamond merchants was carried on by the De Beers Company in England. And again, what the judges here implicitly stated was, it's not the mining that generated the value. It is the trading of the diamonds that generated the value for the company. And the trading was determined in the UK, right? The principal office was here. The judge says the majority of directors met here, and although the diamonds sold came from Kimberley, the profits were realized within the United Kingdom. I hope you enjoy this decision. It is a golden oldie, yeah, I think the thinking was clear. I think the decision, maybe at the time, was shocking. I think looking at it today, it makes sense, and that's why I have a soft spot for this decision. We will talk next week about another case. Bye for now.